Hi, I'm Suzette, and I'll be talking about a topic on rights to privacy regarding the constitutional provisions. Constitutional provisions are a specifically designated rule of law in a nation or state's constitution that cannot be changed by court or the common law regardless of the circumstances that may happen in the future. Provisions limit the government's power over the people's common rights. For example, in the court case of Lawrence versus Texas, where two men of the same sex were found engaging in sexual intercourse in their private home by Hudson police responding to a call that there had been a weapons disturbance in the residence. The case was won by stating that the right to liberty under the Due Process Clause gives them the full-length right to engage in their conduct without intervention of the government. The Texas statute furthers no legitimate state interest in which can justify its intrusion into the personal and private life of the individual, as said by Justice Kennedy in the court case. The Due Process Clause is a law that prevents the government from depriving people from life, liberty, or property without due process of law. In this case, it helped free the two men from being detained unjustly for something that was within their rights.
Relevant Supreme Court decisions. First one is Gridwold v. Connecticut. Connecticut was trying to put a ban on prescription use or sales of contraceptives. The Supreme Court had ruled that the Constitution guarantees a right to privacy, that individuals have the right to decide about intimate and personal matters in their marriage. This fell under the First, Third, Fourth, and Ninth Amendments, which all create that right to personal privacy in the marital relations. Roe versus Wade, back in 1973, Texas was trying to ban abortion. Basically, they were trying to say that the fetus was a person and that they have constitutional rights of its own, that a mother should not be able to have an abortion. The Supreme Court ruled that the fetus is not a person, but a potential life, and does not have constitutional rights of its own. They did put a contingency in there that you are allowed to have an abortion only up until 24 weeks. After that point, you are not allowed to no longer receive an abortion. That would be illegal if you did. This all fell under the First, Fourth, Fifth, Ninth, and 14th Amendments, which all stated that right to personal privacy. Supreme Court had also said that the right to have an abortion was fundamental to a woman's life and future. Planned Parenthood of Southern Pennsylvania versus Casey. The state of Pennsylvania was actually trying to say that women needed consent from their husband in order to receive an abortion, that underage minors had to get consent from their parents in order to get an abortion. The Supreme Court ruled that women do not need consent from her husband or parent for an abortion as an undue burden, and that they reaffirmed the ruling of Roe versus Wade, stating that it is legal to have an abortion as a woman and we do not need consent. This fell under the First, Fourth, Fifth, Ninth, and 14th Amendments, which again state that right to personal privacy. Last one, quick, fairly new. State of Texas actually put a law in saying that you could not have an abortion after 6 weeks. The whole women's health took them to court, and the Supreme Court ruled that the Texas law violated previous rulings like Roe versus Wade, Planned Parenthood v. Casey, which all established that constitutional right to have an abortion up to 24 weeks. Basically said that whole women's health can go to court and file suit against Texas to get that law overturned.
And legislative order. The concept of privacy has over the years faced various controversies in terms of what is private varies among people, culture, and society. We surprisingly still live in an era in which the concept of privacy is being challenged in multiple ways. In 1965, a woman named Esther Griswold was said to have violated the law by prescribing birth control to a married couple. She purposefully challenged the court as she believed that it was a couple's right to decide on the use of contraception. The government, as well as violated the right to privacy by forbidding people to use birth control. During a trial, Griswold's lawyer established that the law violated the 14th Amendment since it inhibited healthcare access for women of low income more than the ones with high income, therefore not ensuring equal protection under the law. When it comes to the right to privacy and the use of contraceptive, Griswold versus Connecticut case appeal on the Supreme Court successfully struck down state ban on any form of birth control in the state of Connecticut and established a constitutional right to privacy. It later laid the foundation for the right to privacy to be later used in Roe versus Wade in 1973, which protected the woman's right to an abortion in a consultation with a doctor. The right to privacy was also cited in Lawrence versus Texas in 2003, which extended the constitutional right to engage in same-sex relations. The case also served as a cornerstone for reproductive freedom. However, Griswold only established a constitutionality of married couples' access to contraception. Then came Eisenthard versus Byrd case, which struck down laws banning contraception for unmarried individuals in 1972, giving them the same right as married individuals got as result Griswold versus Connecticut. Nowadays, 60% of women at the age of reproduction uses birth control in 2020 and 64.9 in 2021. The case essentially paved the way for other cases years later, Bellotti versus Baird and Doe versus Bolton. Some recent ones will include Ayodi versus Planned Parenthood of Northern New England 2006, Gonzalez versus Carhart, and Gonzalez versus Planned Parenthood Federation of America 2007.
Relevant executive orders that pertain to the rights of privacy regarding contraceptives and abortions. You might be wondering what an executive order is. An executive order is a directive given by the President of the United States of America. It is lawful, however, Congress can pass bills to block it, and if unconstitutional, the Supreme Court can overturn it. Likewise, presidents can overturn previous executive orders as well. One executive order is Executive 13535. It was signed into effect on March 24, 2010. It was signed into effect by former President Barack Obama. The effects of the executive order was that it restricted the use of federal funds for abortions and health reform. It was made in order to garner support for the Affordable Care Act in the House of Representatives. Many anti-abortion representatives would not support the Affordable Care Act unless it was written that the federal funding for the Affordable Care Act would not be used in order to help have people have abortions. Another bill, or executive order was promoting free speech and religious liberty, which is Executive Order 13798. It was signed into effect on May 4, 2017. Former President Donald Trump signed it. The effects of the executive order allowed the government to consider issuing policy that would allow employers, schools, and other entities to refuse to cover women's preventative health services on the basis of religious or moral reasonings. Ultimately, this set the groundwork for a case that made it to the Supreme Court. The case that made it to the Supreme Court was Little Sisters of the Poor against Pennsylvania. The nonprofit stated that under the executive order, under their religious grounds, they are allowed to remove preventative care for women on their employees' health insurance plan. Even though it was a win for them and many others, its implications will be far-reaching in the near future.